morning, my lords. Good morning, and your leadership. My name is Jomo J.M. I hold brief for Paul Moite Senior Counsel. Together the team representing the first petitioner, that is Tom Masharia, Andrew Muge, Sakimpa, Faith Waigua, and Victor So for the first petition. Hello.
We do not seem to have the second to sit. Your Lordship, my name is Kiragu Adhuta for the 7th petitioner. Njohi. In addition to that, I am holding brief for Mr. Ndegwa Njiro for the 2nd to the 6th petitioners.
If it pleases the court.
2nd to 6th.
If it pleases the court, in the matter, my name is Simon Nguru. I continue on record for the 8th petition.
Kwa niaba ya mlalamikaji namba 9, kwa jina naitwa Mpaka na patana na Motika Kuku.
With the permission, judges, there is a concern about members who are online. They say they need to be unmuted so that they can participate in the proceedings.
For purposes of counsel who are online, are you able to hear us? If you are online and you are part of these proceedings, can you please say good morning?
Good morning, my lord. This I am Judge.
Thank you. Petitioner 10, petition number 10. Then we'll go to the respondents.
My lords, my lady, if it may please in the matter, my name is Milimo Benson. I do appear for the first respondent. My lord, I'll have the privilege of introducing my other colleagues. For the second respondent, my lord, I, Milimo, hold brief for Mr. Nyamoli and Mr. Gumbo. For the third respondent, my lord, my learned colleague, Miss Opola, is present before you, holds brief for Miss Tanji for the third, fourth, and 7th respondents. And my lord, my learned colleague, Miss Akama, who is present before you, holds brief for Mr. Kuyoni for the 5th respondent. And my lord, I, Milimo, hold brief for Mr. Wanyama for the 6th respondent. And my lord, for the 8th respondent, my learned colleague, Ms. Akama, who is present before you, has been requested to hold brief for Mr. Bita, who appears for the 8th respondent, the Attorney General. Mr. Bita, for the 8th respondent, my lord, the Attorney General. My lord, that will be it for the respondents.
Interested parties?
Ladies and gentlemen, my lord, presiding magistrate, my lord and my lady, my name is Nelson Party. I feel the second of the party, together with David Mishuki, Manuel Sea, Maura Kabak.
Yes.
I think we are done with the forum unless somebody is saying something recorded. I believe that we already read the ruling as of the applications which we had yesterday. This is the ruling in the consolidated applications, in the consolidated petitions. We have considered the submissions of the parties, the facts in those applications, and the arguments and submissions of parties. And we have prepared a ruling which will be perfected in the course of the day, but whose summary is as follows. We have given the facts of the proceedings, the relevant submissions and arguments, and for the purposes of today and this morning, because we don't have much time, we'll give you the abridged version of our ruling. Analysis: having carefully considered the applications, the responses, the party submissions, and the various decisions referred to, the court distills the following issues for determination. 1, whether the applications are res judicata. 2, depending on one above, whether the applications are merited. As to whether the applications are judicata, the nature and applicability of the doctrine of res judicata is a well-trodden path by the Kenyan courts. In petition numbers 42 and 43 of 2014, which were consolidated, that is Kenya Commercial Bank Limited versus Muri Coffee Estate Limited and another, the Supreme Court of Kenya, in an elaborate fashion, illustrated the operation of the doctrine of res judicata. We are not going to go into the details about the doctrine of res judicata, but we have considered it there. We have cited several cases in support of the arguments put forth by parties. And returning to the matter at hand, there is no contestation that the first petitioner herein, Rigathi Gachagua, filed and prosecuted an application seeking conservative orders in Nairobi High Court, Constitutional Petition number E 550 of 2024. On 15th of October 2024, His Lordship, Judge Muita delivered a ruling on that application. For reasons contained in that ruling, the application was dismissed. The nature of the conservative orders which were sought in the said Nairobi High Court Constitutional Petition number E 550 of 2024 related to various facets of the impeachment proceedings against the first petitioner, in this case, before the National Assembly and the Senate. Likewise, the applications subject of this ruling also challenge the very pending impeachment proceedings. Learned Senior Counsel, Mr. Paul Muite, urged this court to nevertheless deal with the instant applications for the main reason that this court as constituted is an expanded multi-judge bench of the High Court as opposed to the ordinary single bench. The respondents did not, however, find favor with the above position. It was vehemently contended that the instant applications ran afoul the settled doctrine of res judicata. This court has diligently addressed itself to the above arguments. Unfortunately, we did not come across any holding persuasion that a decision of an expanded multi-judge bench of the High Court of Kenya is superior to that of a single judge. This court therefore finds that the challenges raised in the instant applications are similar to those dealt with in Nairobi High Court Constitutional Petition number E 550 of 2024. In applying the tenets of the doctrine of res judicata to this matter, we have no doubt and do hereby find and hold that the applications herein are in four corners with the one dealt with in Nairobi High Court Constitutional Petition number E 550 of 2024. The applications are hence caught up by the doctrine of res judicata. For clarity, the issues raised in the applications before us were fully canvassed by a court of competent and concurrent jurisdiction. Having found as such, and for abundance of caution and the completeness of the record, this court will still consider the second issue, and that is whether conservative orders ought to issue. As a well-settled principle in law, a court dealing with an interlocutory application seeking conservative orders is called upon to exercise restraint and to resist the temptation of making final findings at such stage. We have cited cases or authorities emanating from the Supreme Court on that matter. Therefore, a court exercising jurisdiction in an application for conservative orders must sustain that delicate balance by ensuring that it does not delve into and determine issues which largely fall within the realm of the main dispute. The nature of conservative orders was discussed in the Supreme Court of Kenya Civil Application number 5 of 2014, Gatirao Peter Munya versus Dixon Mwenda Githinji. And I have stated what the court said. It was also discussed in other cases which we have referred to in this. On the principles to be considered by courts in dealing with applications seeking conservative orders, the locus classic case of Gatirao Peter Munya, which I have said, comes to fore. And we have delved into what the court said in that case. We have also cited the case of Board of Management of Uhuru Secondary School versus City County Director of Education. We've also cited the case, the court in Wilson, Kaberia, and Kunja. You'll find them in our ruling. Having considered those, then what we then looked at are the elements for granting a conservative order. These are, we are giving them to you in point form, but we have discussed them in detail in our ruling, which we shall give. For the sake of completeness of the record, we have dealt with the merit of the application and whether conservative orders should issue, whether prima facie case has been established. We take the view that the same has been established. The applications raise constitutional issues that require further judicial interrogation. Whether any prejudice will be suffered by the applicants. No prejudice if the applications are not granted at this stage. The process is a lawful constitutional process, and the Senate will conduct a trial where all the issues being raised before the court will be raised and determined. At the moment, we are being called upon to anticipate the outcome of a process yet to be completed. The application at this stage is premature and anticipatory. Should the petitioner not succeed the petitioners still have an opportunity to approach the court after the process. The applications are not without a remedy. On the issue that has been raised that as soon as the Senate impeaches the DP, if at all that happens, that the DP immediately ceases holding office and he cannot reclaim office, we take the view that every office holder can only assume office legally and constitutionally. The assumption of office cannot oust the court's jurisdiction. The court has unfettered jurisdiction to check on the constitutionality of the process at whatever stage. Whether the grant or denial of the conservative order will enhance the constitutional values and objectives in the Bill of Rights, we find that exercising restraint at this stage will enhance and allow independent institutions of government to function unhindered and in their fullness, except in the clearest of cases. It is our view that this is not one such case where intervention is automatic. The issues raised by the parties will require to be interrogated. We therefore find that the enhancement of the constitutional principle of separation of powers will be best served by declining the application at this point. Whether the petition will be rendered nugatory, we find and hold that it will not. The petitions challenging the process of impeachment, the petitions are challenging the process of impeachment. The substratum of the petitions will not be lost. The court is still able to grant a remedy even after the process is conducted, even after the process is concluded, and as such, the court will not be acting in vain. On public interest, we find that the public interest tilts in favor of allowing the constitutional process to proceed unhindered. This position, therefore, deriving from the foregoing, the following final orders do issue. The consolidated applications are hereby disallowed, caused to abide the outcome of the main petitions. That is the ruling of the court.
As we wait, my Lord, the ruling, my Lord, on behalf of my colleagues, I know senior counsel Major would have wished to do this, my Lord. I have the power to thank your lordships for the industry and time that you've taken, my Lord, knowing that we left here yesterday at around 9. Lord, I have no doubt that you might not have had some good lessons. My Lord, we want to thank you for allowing us to have argued before you yesterday and before you delivered of this ruling within the time that's, my Lord. We will wish the Deputy President all the best, my Lord, for the Senate. I thank you, my Lord.
Thank you.
In the leadership on behalf of the first petitioner, this is Jomo for calling in for Mr. Paul Mete, Senior Counsel, for the first petitioner. Noting that the proceedings before the Senate are virtually now commenced at 9 a.m. We don't know the outcome of that particular process, but nevertheless, we would require that we appear before your lordships as soon as practically possible, and preferably, if possible, on the 18th of October this year, so that we can take directions for hearing of the petitions that are now pending.
18th of October is which day?
On Friday, this coming Friday. Senate proceedings, my lords, and your leadership will conclude tomorrow. We don't know what time, but hopefully at night. And it will be necessary that to protect the rights of the first petition, that we appear before you to take directions for hearing of the petitions. Again, my lords and your leadership, because of the unknown outcome of that particular process, it might be necessary for the first petitioner to amend the petition depending on the outcome again. So at this point, this junction in time, we also pray for leave of the court that if necessary we can amend our petition before we take the action to file. If it is granted, my lords, you can comply with the amendment process as soon as possible. If you grant us time, we'll be happy to appear before you on Friday so that this subject matter is not addressed. Thank you.
Petition. Mine is just
Mr. Wathuta?
Yes, Judge.
Yes.
It's just more or less a housekeeping request. Firstly, maybe in the course of the day we can get an indication when we can lay our hearts on the ruling for our review. Secondly, after tomorrow's Senate proceedings, and as indicated in the ruling that remedies can be sought thereafter, and noting the challenges that we had last week in lodging documents at the last minute, we are seeking for permission, if need be, to lodge documents manually, just in case the CTS system will not be accessible like it was last week. And that's all, you're not saying anything.
On behalf of the men, the communities in the park, we also commend the petition thank you on what transpired at the Senate.
Mr. Lempa,
Yes.
what are you saying?
I am saying, my Lord, that we be seeking leave to amend the petition depending on what transpires at the Senate, and will also associate ourselves with the submissions of Mr. DP Rigathi because of the challenges we experienced last week on the CTS. If necessary, the scheme allows us to launch our documents.
My lords and my lady, my name is Simon Mburu, for the 8th petitioner. I associate myself with the submissions of the past 7 and the 9 petitioners, and also wish to seek leave to amend our petition, as the courts have already appreciated the manner in which this matter is mutating, and depending on the outcome of the Senate tomorrow, would then necessitate putting an amendment to fully anticipate that outcome and have it brought before the court.
na riu nä rä itua rä rä a rĩrekererio nĩ majaji kuma kũrĩa igoti-inĩ rĩa Milimani. Na tondũ niĩ ndirĩ wakiri, ona John nĩ wathikĩrĩria ndĩna wakiri haha, na rĩu wakiri kũringana na makiri marĩa ndĩna mo, wakiri ũrĩa ingĩamba kũhe kanya ambe atũtarĩrie kũringana na seniority. Nĩ mũnjĩrie nĩ kũrĩ kĩndũ ta seniority. Ngũigua maũndũ metwo res judicata, ngaigua maũndũ mangĩ metwo classicus, rimo ni gututariria niki gwathi tatariria maito hari ari itua riu ria judge ria igwati na implication yario ni iriku
nyambe njuge macira maria